Thank you, Advocate. You did not indeed, and I was still going to give you because I want to prove that issue of fairness and biasness. Your 30 minutes were still in, but thanks for the presentation. I will now request the initiator to do the same, to respond.
Thank you, Chair. I must start off by thanking my colleague for the kind comments he's made about me personally, and I share his sentiments that I'm an honourable person with himself. I've known him for a long time, and Mr. Ngcukaitobi has, in general, always acted in a manner that I would regard as honourable, wise, and intelligent. But having said that, he makes 2 points in his address to the committee, and I'd like to deal with them in the following manner. The first is I'd like to deal with this question of the composition of the committee and explain why, as a matter of law, the point goes nowhere. And thereafter, I will deal with the question of the application for a postponement. We have prepared written submissions on the question of the postponement, which I would like to hand both to the legal team representing the affected members and the committee. It'll immediately be emailed to the committee, and we have hard copies in the chamber to hand out to the legal team for the affected members. But turning to the first aspect, which is the question of the composition of this committee. The composition of the committee is set out in Rule 154 of the Rules of the National Assembly, which is part of Chapter 12. Chapter 12 deals with the committee system, and in clear and unambiguous terms, how this committee is to be composed, and the appointment procedures are set out in Rule 155. Now, unless and until those particular rules have been declared invalid for whatever reason, this committee is entitled to sit in the capacity it sits, which is to give effect to Section 12 and 13 of the Powers, Privileges and Immunities Act of 2004. And before this committee or before the High Court, there is no challenge to the rules in this respect. I know our learned friends suggest that there is, but we haven't seen it, in the sense that there is this composition has been in place for many, many years. This committee has sat, and it would be interesting, and we would submit odd, for the committee itself to find that it itself is unlawfully or improperly composed. And were there to be such a thought, the best way to deal with it is for the committee to get on with its business and make what is called a finding and recommendation, table it in the House, and thereafter let whoever deems it appropriate challenge the validity of the composition, not by way of just this particular composition, but by way of a challenge to the rule itself. That's how these things are done. So even if the committee is persuaded, which I submit it shouldn't be, that there's any merit in this composition point, it's not available for this committee at this point to take any action by, for example, appointing an independent person like the committee or like in respect of my appointment as the initiator. So the point doesn't get off the ground concerning the so-called unlawful composition of the committee. And this committee, we would submit, can ignore that point in its entirety. Turning to the question of a postponement, I have prepared written submissions, and let me start by saying our learned friend says that today's application for a postponement is, in his view, not Stalingrad. Well, we would disagree. We would submit that today's postponement on its face is Stalingrad on steroids. I will turn to why I say that in dealing with the application for the postponement as was filed on Saturday evening before this committee. There's no merit to the application, and the underlying basis of the application is unfortunately solely lacking in any substance. May I just check with my team whether the heads of argument have been emailed to the committee and given to our learned opponents? So, Chair, I trust that the committee members have now all received soft copies or by way of email of our written submissions. And I would take the committee to it because perhaps in listening to me, it'll be easier and quicker were the committee members to read my submissions as I proceed. In paragraph 1, we deal with the question of the notice to the 6 affected members. In paragraph 2, we deal with the content of those notices. And importantly, Chair and other committee members, what is interesting is that the notices were served on the 6 affected members on a Tuesday night. That following Friday night, or not Tuesday night, Tuesday afternoon, but that following Friday evening at 7:24, the attorneys for the affected members drafted a letter to the Speaker and the Chair, and on the Sunday, the Speaker, through the State Attorney, responded. But it's important to note that on the Friday evening's letter, which was written by Ms. Cupido of Ian Levitt Attorneys on behalf of the 6 affected members, certain points were raised concerning why a postponement should be granted, including the question of the High Court litigation, including the fact that there were, for example, 640 pages contained in the bundle, the hearing bundle. And on the Sunday letter in response, all of these points were taken care of so that, for example, it was explained in paragraph 20 of the State Attorney's letter to Ms. in response to Ms. Cupido, that it's all very well saying there's 640 pages in the bundle, but almost all the pages are formal documents such as legislation, the rules of the National Assembly, joint rules, and there was nothing, open quote, new that the 6 affected members would need any time to consider. So the insufficient time on the basis of the bundle is a non-starter. And one sees in paragraph 4 of my submissions that Ms. Cupido's letter requested certain information. There was a request, rather it was framed as a way of a demand that the hearing be postponed to a date in 2024. Again, after judgment by the Western Cape High Court in a matter to be heard on Monday, the 4th of December, 2023. The committee has heard from our learned friend the similar refrain today, and that refrain is included in the application for the postponement that was filed on Saturday evening. And what Ms. Cupido did in her letter was to threaten a High Court interdict to stop these proceedings, prohibit these proceedings commencing. And the response from the State Attorney was, that is inappropriate. It's inappropriate to approach the High Court, rather approach this committee, which is what they did. But the important point that I want to stress is that the 6 affected members knew as long ago as Friday, the 10th of November, that they wanted a postponement. That's 3 days after having been served the notices. And yet they waited 9 days to bring their formal application, the substantive application for a postponement, without any proper explanation. And it's a factor that this committee will take into account in deciding whether to grant the postponement. They knew early on, so they would argue, that they didn't have sufficient time, but they waited 36 hours before the hearing, they bring their substantive application. And the courts have replete with authorities which say, if you know you're going to bring a postponement, if it's a good faith application for postponement, do it as soon as you know you want postponement. As soon as you're going to make your application for postponement, make it. But if you wait till the last moment, you're almost hijacking the decision maker to say, well, it's too late. We have to now listen to what they say at the last minute. So we take it further, and if I may turn to paragraph 11, it says there is now a substantive application in which a postponement is sought. And we submit that in paragraph 11, that this postponement application is an abuse. It's a clear stratagem of the 6 affected members to avoid taking responsibility for the alleged disruptive conduct at Sonar. They wish to evade the hearing and the charges at all costs. They are ducking and diving, and such conduct should not be tolerated. And I may just turn away from the note to make this point. Our learned friend has suggested, and we disagree with the suggestion, that the test for the charge of approaching the president and the speaker in a threatening manner is to be determined on a subjective basis. We disagree with him. It doesn't matter what the president, what the speaker, what the 6 affected members thought. It's what the objective facts show happened at the event. So if the 6 affected members had absolutely benign or peaceful intentions into jumping onto the stage in the middle of Sonar, the fact that what was going on through their minds is not an inquiry that this committee will consider. Similarly, what the president thought or what the speaker thought is not of relevance. If the president thought, well, I'm not threatened because I have the VIP protection, I'm not really threatened by 6 people jumping onto the stage while I'm sitting here. Or if the speaker thought similarly, she was at the back end of the stage and she couldn't be threatened because she was quite far from the action. It's irrelevant. So we would submit that it's an objective inquiry, and this committee will draw inferences from the conduct which the 6 affected members were involved in. So the conduct involving the 6 affected members is where this committee will go from an objective perspective. What are the inferences that can be drawn from jumping onto the stage at the time and in the manner that they did so? It's a simple issue. I then turn to the issue of Stalingrad, paragraph 13 of our note. This conduct of delay is classic Stalingrad. The 6 affected members have taken every step, reasonable and unreasonable, just to ensure that the hearing does not commence. On the version testified to by Ms. Cupido on behalf of the 6 members, a postponement is certainly not warranted. So what the committee will do is read and analyze and consider the application by the 6 affected members as testified to by Ms. Cupido. 4 corners of the application are Ms. Cupido's evidence and my learned friends addressed this morning, and make a decision on that. Simply put, we say in paragraph 15, the 6 affected members on their version have not made out a proper case to be granted a postponement. And so we conclude by saying at this part of the heads, there should be no postponement. We turn to give the committee some assistance by how the courts have dealt with applications for postponement. And we start off by in paragraph 14, it's 18, following the 14 to 17 paragraph. But in paragraph 18, we say in court proceedings, a postponement of a hearing is an indulgence. Let me repeat, it's an indulgence. And in 19, that indulgence will only be granted where the party seeking a postponement demonstrates that it is in the interest of justice to do so. That is the burden of a party seeking a postponement. Now, we accept that this committee is not sitting as a court, tribunal, or arbitration forum. It nevertheless has the power to consider an application for a postponement of a hearing. Let me just stop and say, it is suggested that this committee would find the 6 members guilty or not. That's not true. What the committee does is table a report in the House, and that report will include findings and recommendations. The Act, the Powers Act makes it, and the rules make it clear that the House itself is not bound to follow that report. So this committee plays a recommendatory role rather than a role of making a finding one way or the other. That being so, we make the point that when it comes to the question of a postponement and the court's guidance as to how the committee must consider and exercise its discretion, the criteria, the factors that the courts have set out play what we call an R40 or RI role in how the committee would decide. In other words, to the extent that a court has a discretion, the discretion is far more narrowly tailored and far more narrowly exercised when it comes to the committee itself. So the committee itself will decide, do we grant this party an indulgence? The committee will consider Ms. Nkcukaitobi's affidavit with our learned friends' oral address this morning and decide with reference to the factors that the courts have set out, but those factors must be given heightened awareness in deciding whether to grant a postponement or not. That point is made in paragraph 22. In paragraph 23, we submit that a proper case must be made out. So there would have to be an explanation. Now, we've heard from our learned friend that the members, they may wish to call the president, call the speaker to hear what's in their mind. That case is not made out anywhere. It's not in the letters addressed by Ms. Nkcukaitobi. It's not in the affidavit addressed by Ms. Nkcukaitobi to this court. So one has to look at what is the application that serves before this committee. And the application doesn't talk to any of those types of considerations of who it wishes to call, who the 6 members wish to call, and why. So one would look at the postponement itself. And we say, as far as being given an opportunity to bring a constitutional challenge is concerned, in paragraph 24, the courts have now put their face against the notion that where there is a hearing, whether it be a criminal trial, a labor dismissal hearing, disciplinary hearing of any type, that a party facing the hearing should be entitled first to approach the courts with a constitutional challenge, and thereafter, if they fail, let the hearing go ahead. Courts have said that's not the way to do it. The general way to do it, have your hearing, and if you are not successful in opposing whatever's happening, if you're found guilty, or if you lose the labor case, or if you lose this disciplinary, then at that later stage, you may appeal the ruling, review the ruling, and bring your constitutional challenge. Not upset the whole apple cart by bringing your challenge and then staying the proceedings for a year, for 2 years, for however long, while this constitutional challenge is traveling through the courts. And the Supreme Court of Appeal and the Constitutional Court have said over and over that way of doing things, of staying the proceedings, obtaining postponement after postponement after postponement, is inappropriate. Get on with your hearing, and if you're not successful, then you can bring your challenge. And that's classically the case like this. So, for example, let's assume the 6 affected members have their hearing, and it turns out that the report is one that the report that's tabled in the House is one that they feel comfortable with. They wouldn't bring the constitutional challenge because they would have been vindicated before this very committee. As it is said, perhaps the committee will find that they didn't jump onto the stage in a threatening manner. They didn't disrupt the proceedings as set out in Section 12. Well, then there's no need for the constitutional challenge to be brought. There's no need for all of the, let's call it, interesting constitutional aspects, the composition of the committee to be considered. And they would have been, open quote, not have any black mark or stamp against them. And the 1 million or so voters who have asked those representatives to be part of the House, they would have had their needs properly considered. So we say in paragraph 26, in this case, the committee may, after hearing evidence and considering argument, table the report in Parliament recommending that no action of any kind be taken against these members. And the members may feel that the inquiry conducted was reasonable and procedurally fair, so there would be no need to challenge its report in the House and the procedures adopted by the committee. Now, the point I want to make here is that To predict that the committee will act in an unreasonable and procedurally unfair manner is unfortunate and not warranted by the facts. This committee will act reasonably, will act in a procedurally fair manner, and it's not at this stage for the affected members to second guess how the committee will run its proceedings. We turn to paragraph 27. It's a point that I've already made. This application fits into the premature preemptive category repeatedly warned against by the courts. The postponement application is inter alia on the High Court in constitutional challenge, and then the arguments again are set out in paragraph 29 and 30. Ms. Cupido's arguments for postponement are premised on the potential unfairness and unreasonableness, not the actual unfairness or unreasonableness. And we say if it's potential unfairness or unreasonableness, that in and of itself is no basis to grant a postponement. This committee would then be suggesting, well, they claim they need more time, they claim there's a constitutional challenge, they claim there's 740 million. We as the committee, we don't think we're going to act fairly and reasonably, so we postpone. Doesn't work that way. This committee will do what it is required to do and continue its proceedings until such time as it finalizes the proceedings. And at that point, if the affected members are dissatisfied that they didn't obtain natural justice, fairness, reasonableness from the committee, it is at that point in the future that they may take up these challenges. So in summary, we say in paragraph 32, the members seek a postponement to await the outcome of some High Court case which may have no relevance or any bearing to this hearing. It is emphasized in paragraph 33 that before the House may take any disciplinary action against a member, the committee must, and it's an obligation on this committee, inquire into the matter in accordance with a procedure that is reasonable and procedurally fair. And if it ultimately transpires that the High Court and possibly the Supreme Court of Appeal and Constitutional Court judgments have some bearing on the reasonableness of this hearing and its procedural fairness, the affected members will certainly not be without a remedy. They'd be entitled at that stage in the future to bring whatever challenge they would want to make concerning the so-called irregularity of these proceedings. And just let me say to the committee that even were the High Court challenge to succeed, that's not the end of the matter as far as the hearing or the fairness and reasonableness of this hearing is concerned. Section 172 sub 1 sub B of the Constitution gives the court wide remedial powers to make any order that is just and equitable in the circumstances. And it may well be, and one can't predict, that were the High Court to come to the assistance of the EFF and the Menti and Marais applicants as far as the constitutionality of that which is being challenged, it may, and we would submit probably would, make a ruling that despite the infirmities of the legislation or the rules, the proceedings would not be regarded as unreasonable or unfair. That would be what we would submit would be a serious possibility as to just and equitable remedy that the court might grant. But it's at that stage in the future that the affected members would have the remedies or rights, whatever they may seek, to challenge these proceedings. But what they try to do effectively is to avoid even having the hearing commence. And when they do that, one has to look at the substance of the application that was brought. And I've made the point over and over, Ms. Cupido's affidavit are the four corners of the evidence that one will consider, that the committee will consider, and they just do not get off the starting point. In paragraph 38, I've made the point. So, Chair, in paragraph 39...
Chief, I'm calling a point of order.
What is your point of order, Honorable?
His 30 minutes is finished, Chairperson. His 30 minutes is done. He's been addressing here for over 30 minutes. He must be organized.
I think I've had 21 minutes, Chair, according to my clock, but I might be wrong. 21 minutes at this point.
He's not talking to you. There is procedure in Parliament. Keep quiet. He's talking to the
Chair.
chair. Why are you talking? Why are you talking when he's talking to the chair? It's not talking to
Honorable
you.
Malema, you must
That's the
also
problem
stop.
of white supremacy. That's the problem
No,
of white supremacy.
According
You think you can just
to my
disrupt us like that?
according to
Honorable Chair, we are not going to allow
my
this.
watch, he's left with 6
Dlagude, you
minutes.
wanna allow
Honorable
what?
Minister.
Dlagude, you wanna allow what? You wanna allow what? We're not Dlagude. You wanna allow what?
Honorable Malema, please, can you be orderly, please? I'm chairing. Can you respect the chairperson? You may
Yes.
raise your point of order, I will recognize you, but I'm responding to Honorable Ndlozi's point of order that advocate is left with 6 minutes. Can we allow him to proceed, please?
Yes, Chair.
Proceed, initiate.
Thank you, Chair. In paragraph 39, I was suggesting that the comments of the Constitutional Court in a case called National Police Services Union and others versus the Ministry of Safety and Security and others from 2000 should dominate this court's consideration of the application for postponement. In paragraph 4, the Constitutional Court stated the postponement of a matter set down for hearing on a particular date cannot be claimed as of right. An applicant for postponement seeks an indulgence from the court. In this respect, the applicant for a postponement must show that there is good cause for the postponement. And I move on to Myburgh Transport in paragraph 40, 41, Gravenstone versus Neertling, and in numerous other cases to the same effect. In 43, there's the full bench of the Cape High Court where the application was for a postponement in circumstances where the minister in that case, the Minister of Home Affairs, had filed no papers whatsoever in a constitutional challenge to legislation. And the court was put in a difficult position because here it was deciding whether legislation was unconstitutional without any papers from the government. And the court refused a postponement partly because the application for a postponement was brought at such a late stage. So the real question is the late application in this case, together without any merit and substance to the application, we say would suggest that there is no merit. In paragraph 48, I've dealt with the bundle, and I've dealt with the difficulty that the 6 affected members have, is that they complained about the size of the bundle when it was explained in correspondence that the size of the bundle was of no moment because the words are, the documents are all formal in nature, such as the Act and the rules. There's no prejudice of any kind to the 6 affected members with this weighty bundle. There was no response from Ms. Cupido. The insufficient time aspect, which is in paragraph 50, is a non-starter. My learned friend is quite correct. Item 1 of the schedule to the NA rule states that a notification must be delivered to the member at least 5 working days before the hearing. In the present case, the notices were delivered 8 working days before the hearing. I know that there's a debate whether it was 7 or 8 days, but that's not the point. The real point is it's more than enough time for what is regarded as a single incident. It's 6 members having been asked to leave the National Assembly for good or bad or indifferent reasons, jumping onto the stage in circumstances where the President of the Republic of South Africa and the Speaker of the National Assembly and other presiding officers were present in a particular manner. And there may be evidence to the effect of what objectively the inferences that this committee can draw. So we submit in conclusion, paragraphs 51, 52, and 53. The current application 52 for postponement has been brought for one purpose only, to delay the commencement of the inquiry on unsustainable grounds. It has not been brought in good faith. It has been brought at the 11th hour in what may legitimately be regarded as an ambush. The application for postponement must be dismissed. And we would conclude there, and I hope that I have complied with my 30 minutes. I think I'm on 29 minutes, Chair, but thank you.
Thank you, Initiator. Before I go back to the legal team of the affected member, I would like to check with honorable members whether you do have Any clarity questions to the two presentation, both by the legal team of the affected member as well as the initiator? I'm allowing that space now for you, honorable members of the committee. Please assist me by observing hands, our officials, staff members, if there are any. If there is none, it's fine, we'll proceed. And delay, do we have hands?
The Deputy Chief Whip, Chairperson.
Deputy Chief Whip, you are recognized.
Thank you very much, Honorable Chairperson. Good morning to yourself, the initiator, the affected members, legal team, and everyone on the platform. Honorable Chairperson, I want to welcome the presentations made by both sides. But I think it is our responsibility as members of parliament to clarify some of the issues, even though the initiator has already done so. But we really need to emphasize this. Honorable Chair, I won't waste your time, but just to indicate that this committee is not made up of ANC members. There are other parties, namely the ANC, DA, EFF, ATM, and IFP. And the rules of the National Assembly allow any member of parliament to participate in any committee, even if they are not members of those committees. So they allow for that. So any member of parliament is allowed to sit. And again, parliament, like any other institutions that are there, have its own arrangements. We are not a court of law. We are members of parliament. We have our own mechanisms, that we use. I think it is proper for us.
There is a point of order.
Oh,
Can we
okay.
allow
My
that?
apologies, Chair. My
Yes,
apologies.
can you allow that point of order?
It would
Honorable
be
member.
helpful. It would be helpful if you would chair this meeting, because you said you're calling for questions, not some narrative we're being given here. We must not be patronized. We know what this committee is. Why is she giving us a story? You said questions, and you must also stop sleeping there because you called for questions. Please.
It is not night. I'm not sleeping. Let us respect each other, because if I bounce back, you won't like that. Your point of order is sustainable. I was also going to respond to that other members must come up with clarity-seeking question. But thanks, because you alerted me that. But I observed that because the committee will still go and deliberate on that, and you are in order. But don't put any vulgar words which won't allow me to do that to you. So let's respect each other right from day one. Thank you. Honorable Tlakode, honorable member is in order. You are trying to outline, clarify the rules, and the initiator has done so. According to me, as the chairperson, I was requesting clarity-seeking questions. If we don't have, let's leave it in that way, because we will still have time to go and deliberate in the committee. So with due respect, the honorable member is in order. What I don't like is to tell me that I must not sleep. I'm not a child. Thank you. Honorable Tlakode, can you stop there?
Thank you.
And then
Thank you very much.
We'll go back to our legal team of our affected members to respond on the response by the initiator. Thank you.
Thank you very much, Honorable Chair. Order taken. Thanks.
Thank you, Chairperson. Let me start. I have 10 minutes, if I'm correct, Madam Chair.
Thank you, Advocate. You are right. You have got 10, but because you managed your time in the first round, I may allow you to add few.
All right.
I want you to be free, because here we're in the hearing, we're listening to each other. That all the party pattern is being observed. Thank you, Advocate. You may proceed.
Thank you. Thank you, Chairperson. Let me start then with the first point I tried to make, and maybe I was not clear, and I take responsibility for not being clear. The point I make is that the committee is ANC dominated. According to our calculations, in its current composition, it is 61% ANC. 61%. Decisions have to be taken on 50+1, which means any resolution that has the political patronage of the ANC will be carried through. There's no one who can say anything about that. It's a fact that the ANC dominates this committee at 61%. It's even higher than the National Assembly composition of 57%. The question you have to ask yourself is whether any reasonable person acting reasonably will believe that EFF MPs, including its president and deputy president, that have been subjected to a disciplinary hearing for a political act will receive a fair hearing. That does not mean you yourselves are dishonest, but it means that you are perceived to be politically biased against the EFF, and it is your job to carry out the mandate of the ANC. That is what the judges have said. But where you are going to sit in judgment, that's the point. Where you are sitting in judgment of your political opponents, it is absolutely essential to remove the stigma of bias. Now, I said at the commencement of my address, Madam Chair, that the rule against bias applies. Mr. Katz has not responded to that. He must be taken to accept that the rule against bias applies. Number two, I said at the commencement of my address that you are bound by section 12, subsection 3, subsection A of the Powers and Privileges Act. What that section requires you is that you must inquire into the matter in accordance with a procedure that is reasonable and procedurally fair. So you have a duty to set up a procedure which would be reasonable and procedurally fair. In our view, the procedure that you must set up is the procedure where a judge, a retired judge, conducts an inquiry into the facts and finds out who did what. There is no provision here that you must substitute yourself as a fact finder. Your job is to conduct, in fact, your job is to inquire in accordance with the procedure. So item 1 is develop the procedure. Develop the procedure. And the first item on that procedure is make sure that there is an unbiased judge who's hearing the matter. He can recommend to, he can make findings of fact and recommend to you, and you can vote as you wish. But the fact-finding stage is the procedure that must be presided over by a judge. Now, Madam Chair, you've been here, we've all been here. Mr. Katz has never said that the procedure of appointing a judge will be unlawful. Why? Because he himself knows that a retired judge is a guarantee of independence and fairness. He himself knows that you cannot subject EFF MPs to a political machine of the ANC over a political act. Everybody knows this. You can ram through this, railroad it because you've got the numbers, but it will not substitute the cogency of the legal submission that you have to ensure that the procedure you adopt is reasonable and procedurally fair. Now, that does not mean as a fact you will be biased. It means you are perceived to be biased, and perception of bias is as good as actual bias. Number 3, Mr. Katz says, look at the rules. And then he cites Rule 154, 155. Those are irrelevant rules. You can close your eyes as far as those rules are concerned. The relevant rules are Rule 211, 212, 214. They talk about the composition of the committee. We have no objection to the composition of the committee. We've never said anything about the composition of the committee. Our only issue is who is going to conduct the fact finding? Is it a judge or is it the political opponents of the EFF? Now, when you look, and Mr. Card says, this committee is not going to make findings whether people are guilty or not. But that means he has not paid attention to Rule 214. Look at Rule 214. It says, 214(2)(b), the committee must table a report in the assembly on its findings, underline findings and recommendations in respect of any alleged contempt of parliament as alleged in section 13 of the Powers and Privilege Act. And then it says, C, if it is found that a member is guilty of contempt or misconduct, the committee must recommend an appropriate penalty from those contained in section 12(5) of the Powers and Privileges Act. So anybody who says that you have no power to make a guilty finding can only say so in ignorance of the rules. We say you should not be ignorant of your own rules. You must know your own rules that you must make the guilty finding. Our submission is the rules do not require you to sit as the disciplinary committee. They empower you to appoint an independent person to make the fact finding so that there is no perception that the ANC is persecuting its political opponents. In other words, it's abusing its majority in parliament. So the debate about the rules is an irrelevant debate, completely irrelevant, because we've never said we want the rules to be struck out. We've never said we want the committee to be differently constituted. What we have said is the rules give you the power to appoint an independent judge in the same way as you've appointed my learned friend who is an independent initiator. Once you have done that, you will take the report of the independent judge, and thereafter you will deliberate and you will vote, and whatever the outcome of that vote is. But what will not happen, you are not going to have Mr. Malema being the subject of interrogation over a so-called misconduct, which is purely political, by his political opponents. That is the argument. And so far, I'm afraid to say there has been no answer to that argument. The only thing that has been done is we have been given the rules. We know the rules, we've read the rules. We could not have come here without having read the rules. We came here because we've read the rules and we have said there is a way in which you can protect yourselves from acting unlawfully by appointing a judge. And nobody has said that the judge is not the correct person to look into whether Mr. Malema committed misconduct or not. And thereafter, you will vote. You still have your majority and you can still decide what you want to do. And that it is wrong to say that there will be no guilty finding. The rules expressly use the word guilty of misconduct. Now, that's item number one. This idea that we are going to act fairly. We are going to act fairly. If a judge is biased or is perceived to be biased, he or she is removed before the case. The judge is not allowed to run the case. And after having run the case, to say, oh, look at me, I've given you such a fantastic hearing. That is contrary to every rule that exists in the common law, in the Constitution, and elsewhere. The judge is removed at the beginning. We don't ask you to be removed. We ask for something less than that. We say, conduct the fact finding before a judge, take the report, and we will go there, we will defend ourselves. So that's very, very important to understand what the point that is being argued is. In fact, it goes back, I think it was Honorable Hlakude. I heard from that question that maybe it was my fault that I didn't clarify what I was saying, and that is why she's going on a wrong track in assuming that I'm attacking the rules. Instead of saying, I'm asking you to enforce the rules, because the rules require you to act fairly, reasonably, and rationally. And I'm asking you that in order to act fairly, reasonably, and rationally, appoint a judge. And so far, no one has ever said why a judge should not be appointed. There can only be one motivation where a judge is not appointed. It's because certain people want to settle political scores. That can be the only explanation why a judge should not be appointed. We have so far had no explanation whatsoever. So we insist on our initial submission that we ask you with the greatest of respect, get a judge, and Mr. Malema will subject himself to an independent judge. And that does not diminish your standing. That does not diminish the autonomy of Parliament. It retains it and it reinforces it. In fact, it even makes it more legitimate that you are prepared to say, let's get a judge, let's get advice, and then let's take it forward. By the way, this is not a radical thing that I'm suggesting. When you are disciplining yourselves, disciplining the public protector, you know the first thing you do? The first thing you do, you get a judge. You had Justice Ngabinde. You had, I think it was Justice Mohoro in the two matters. Even
Advocate, sorry, your time is up, but I'm giving you 3 minutes to wrap up. Thank you.
Yes, all right. So that's on the first issue. Let me leave that. I wanted to make the two examples. Public protector, you've got a judge who makes the first determination and then it goes to Parliament. So that's nothing new. Then let me go in the 3 minutes that is left to the issue of postponement. My colleague says, we left it too late. You know, Madam Chair, I don't know if you have this bundle of the postponement application in front of you. If you have it, I will ask you to go to page 39 and 40. We wrote a letter to, not me, but my attorney wrote a letter to Parliament on the 10th of November. And they said, look, can we please get this thing postponed? The state attorney, now that is Mr. Katz's client, instructing attorney, wrote back at paragraph 7, they said, we point out that it would be premature and an abuse to approach a court without first approaching the Powers and Privileges Committee with whatever complaint your clients may have regarding the notices and charge sheets that were served. So they said they cannot give us an answer. We must come to this committee to request the committee. Now, Madam Chair, listen to this. When we come to the committee, they say we came to the committee too late. They themselves said they couldn't give us an answer. The state attorney said, I can't give you an answer, go to the committee. Today we are in front of the committee. What are we being told? We are being told we came too late. So there is a fundamental inconsistency that is being played by the state attorney side. Then the last point to be made goes into the issue of Stalingrad. I have never seen a case where an application is made for the first time and where there is a commitment to hear the case in a month. I've never seen that case being reduced into Stalingrad. It's the first time. And so you have to be careful not to be hoodwinked by fancy terms, Stalingrad. It applies to Mr. Zuma's case, the judges have found. It doesn't apply to Mr. Malema's case. And Stalingrad applies in criminal cases and it doesn't apply in parliamentary proceedings. This is the first application, and we have said we are going to be back in January. We need about a month to prepare. And then somebody jumps Stalingrad. You have to be taken seriously in your job as parliamentary MPs. So, in summary, we say, appoint a judge, we will appear. Number two, we say, give us time. We need about a month to consider this. The submissions have been circulated, I'm told, for the benefit of the committee. Thank you, Madam Chair. I hope I have stayed within the extra 3 minutes.
Thank you, Advocate.